Madam Doorkeeper.
Mr. Speaker, the President, President Pro Tem, and the members of the Senate wait entrance to the House chamber.
Madam Doorkeeper, please allow the President Pro Tem, and the members of the Senate to enter the House chamber, and will the messenger please escort them to their designated seats. All members, please take your seats. All members, please take your seats. At this time, it is I have a sort of a sad duty, and that is to introduce at the, we just were joking, last scheduled joint session during his tenure as Lieutenant Governor, Lieutenant Governor Duncan. He will be going on to bigger and better things. I've reflected a lot over the years about the kind of great training and upbringing he had here in this house. We raised him for greatness, and he went on and attained it. Mr. Governor, I want to tell you I have enjoyed working with you. I admire the courage of your convictions, and I wish you and your family all the best going forward. And it's my honor now to introduce Lieutenant Governor Jeff Duncan.
Thank you. Truly is an honor to be back in this chamber for my entire life. I'll remember so many conversations, so many relationships, so many life lessons learned inside this chamber for myself and my family. So it truly is an honor to be here as we move forward. Mr. Speaker, thank you so much for your friendship along the way. Thank you so much for a working relationship that continues to be very, very productive as we continue to work for 11 million Georgians each and every day. Members of the General Assembly, the joint session will come to order, and I'd ask that all members take your seats. Mr. Doorkeeper.
Mr. President, the Honorable David E. Nahmias, Chief Justice of the Supreme Court of Georgia, the Honorable Michael P. Boggs, Presiding Justice of the Supreme Court, the Honorable Brian Rickman, Chief Judge of the Court of Appeals, and the Honorable Amanda Mercier, Vice Chief Judge of the Court of Appeals, awaits entrance into this chamber.
Mr. Doorkeeper, please allow the Honorable David Nahmias, Chief Justice of the Supreme Court, the Honorable Michael P. Boggs, Presiding Justice of the Supreme Court, Honorable Brian Rickman, Chief Judge of the Court of Appeals, and the Honorable Amanda Mercier, Vice Chief Judge of the Court of Appeals, to access this chamber. The House Doorkeeper will escort them to their seats. I'd ask that all members take your seats. Mr. Clerk, can you please read a resolution?
House Resolution 705 by Representative Burns, the 159th Hatchet of the 150th and Leverett of the 33rd. A resolution calling a joint session of the House of Representatives and the Senate for the purpose of hearing a message from the Chief Justice of the Supreme Court, inviting each other Justice of the Supreme Court and each Judge of the Court of Appeals to be present at joint session and for other purposes.
Thank you, Mr. Clerk. I'd like to take a moment to recognize some very special guests with us here, or folks that work around us each and every day. I'd ask that you please stand when your name is called. First and foremost, we've got the Speaker of the House, David Ralston, who's with us here this afternoon. We've got the Speaker Pro Tem, Jan Jones. Thank you so much for your service. President Pro Tem, Butch Miller. And all of our constitutional statewide officers, if you would stand and we'd all give you a hand. Thank you so much. At this time, it gives me a great pleasure to introduce to you a great Georgian, the Honorable David Nahmias, Chief Justice of our great Supreme Court here in Georgia. Justice Nahmias was appointed to the Supreme Court by Governor Sonny Perdue in 2009 and was sworn in as Chief Justice of our Supreme Court on September 4th, 2019. The son of immigrants from Egypt and Germany, Chief Justice Nahmias was born in Atlanta on September 11th, 1964. He attended Duke University, where he graduated second in his class and summa cum laude, and Harvard Law School, where he graduated magna cum laude and was a classmate of U.S. Supreme Court Justice Neil Gorsuch, and as an editor of the Harvard Law Review along with former President Barack Obama. Chief Justice Nahmias then served as a law clerk for Justice Scalia on the U.S. Supreme Court. In 1995, Chief Justice Nahmias joined the U.S. Attorney's Office in Atlanta. Shortly after the September 11, 2001 terrorist attacks, Chief Justice Nahmias returned to Washington and became one of the Justice Department's leading terrorism prosecutors, coordinating the investigation and prosecution of terrorist activity across the country and internationally, and assisting in counterterrorism policymaking. On December 1, 2004, Chief Justice Nahmias was confirmed by the U.S. Senate as the United States Attorney for the Northern District of Georgia. Chief Justice Nahmias was received numerous local, state, and national awards and honors for his public service. It is my great honor to present to you the Chief Justice of our Supreme Court, the Honorable David Nahmias.
Thank you, Lieutenant Governor Duncan, Speaker Ralston, President Pro Tem Miller, Speaker Pro Tem Jones, members of the General Assembly, constitutional officers, my colleagues who are here with me today, Presiding Justice Boggs, Chief Judge Rickman, and Vice Chief Judge Mercier, our fellow justices and judges who are watching, and my fellow Georgians. Thank you for this opportunity to present to this gathering of the people's representatives my report as Chief Justice on the state of Georgia's judiciary. In past years, these reports have often discussed a variety of accomplishments of the judiciary in the preceding year, along with an assortment of priorities for the coming year. But I'm going to focus on only one topic, the challenges to our judicial system created by the COVID pandemic. Because while we do have other accomplishments and priorities, dealing with the pandemic's consequences is consuming the attention of Georgia's judges at all levels, and it will for the foreseeable future. I will lead off, as good lawyers always should, with the most important point. The resolve of Georgia's judges to uphold the rule of law and provide equal justice for all is as strong as ever, in spite of the difficulties created by the COVID pandemic for almost 2 years now. We must never lose sight of the importance of our courts. Citizens and businesses rely on courts to resolve their disputes fairly and peaceably through decisions by impartial judges and juries rather than by whoever has better weapons, more money, or the most political power. Our judicial system is critical to the rule of law that is the very foundation of this state and this nation. My parents came to this country from colonial Egypt and Nazi Germany. And I've heard and studied what it's like to live under the rule of tyrants rather than of law. We are truly blessed to live in a state with a fair and effective judicial system. But as with all areas of our society, the COVID pandemic has created enormous challenges for our judicial system. And like most Georgians, we're frustrated that every time we take a couple of steps forward, a new wave of COVID cases comes and knocks us a step back. What we still call COVID-19 has now been with us in 2020, 2021, and into 2022. Yet through it all, Georgia's judges, lawyers, and other participants in our justice system have demonstrated remarkable perseverance, creativity, and resolve to keep our courts operating, even in areas with very limited resources and facilities. Even at the start of the pandemic, when much of our society shut down and people were told to stay home, our courts always remained open for matters essential to the protection of life, liberty, and property, like criminal warrants and bond hearings, domestic abuse protective orders, and child removal matters. Last July 1, the statewide judicial emergency order ended, along with the governor's statewide public health emergency. As Chief Justice and in consultation with the Judicial Council of Georgia, which I chair, I continue to provide advice and guidance to judges around the state on how to deal with changing COVID conditions. And our Judicial COVID Task Force, led by my colleague Justice Sean Ellen LaGrua and Chief Judge Russell McClelland of the Forsyth County State Court, also continues to provide advice and guidance to courts and lawyers on COVID response. But it's advice and guidance, not orders. As we've learned more about dealing with the ever-changing COVID challenges, we've realized that the best approach at this point is not broad statewide directives, but more tailored responses at the local level. And in this regard, I want to recognize and thank the leaders of our local judicial systems, the Chief Superior Court judges of our 50 judicial circuits, who have taken on the primary responsibility for addressing COVID as it affects the courts in their areas. We've learned that if there's a COVID outbreak in a particular type of court or a particular area of a courthouse, it's not necessary to declare a lengthy local judicial emergency order for all the courts in the county or the circuit. A good example of this occurred during the week between Christmas and New Year's, when the Omicron wave passed over Waycross and infected or exposed several judges and staff members in the Ware County Magistrate Court, who then needed to isolate or quarantine. Chief Superior Court Judge Dwayne Gillis, working in consultation with the Chief Magistrate Judge, did not issue a local judicial emergency order affecting the entire Waycross Circuit or even the entire Ware County Courthouse for the full 30 days allowed by the judicial emergency statute. Instead, Judge Gillis issued an order tolling deadlines in just the magistrate court for just 15 days with provisions to ensure that the court was never closed. Court documents could still be filed using a Dropbox in front of the courthouse, and essential hearings could still be conducted by scheduled appointment. This sort of targeted and limited response to COVID outbreaks and risks is critical to keeping our judicial system as operational as possible. Another important response to COVID has been technological, particularly the use of remote video conference proceedings to keep cases moving. Now, judges tend to be pretty set in their ways. We're not usually early adopters of new technology. But the pandemic forced us to adapt, and in 2 years, we've probably made as much technological progress as it would have taken 2 decades otherwise. And I want to recognize the extraordinary work done by the IT professionals in the judicial branch, like Bob McAteer and his team at the Supreme Court, to support this technological transformation. Almost all courts in Georgia have used video conference technology, Zoom, WebEx, Teams, all sorts of platforms, to conduct proceedings virtually and therefore safely, even when COVID conditions are at their very worst. When Cobb County Superior Court Judge Tang Kell's son had COVID early in the pandemic, Judge Kell was able to continue to conduct hearings virtually from a makeshift courtroom he set up in his bedroom, complete with an American flag he swiped off the front porch. While his whole family quarantined, Judge Kell live streamed to his open courtroom in the Cobb County Courthouse so the public would continue to have access to the proceedings. As COVID conditions ebb and flow, so too can the use of these remote proceedings. My court, for example, would prefer to hold our oral argument sessions in person in our beautiful new Supreme Court courtroom in the Nathan Deal Judicial Center. But remote arguments work fairly well, and we quickly started using that technology after the pandemic hit, as did our Court of Appeals. Since last summer, we've gone back and forth between in-person and remote argument sessions. As the Omicron wave peaked last month, we decided to shift back to remote arguments. That enabled me to participate and preside over the oral arguments, even though I actually had COVID at that time and was isolating in my home. There's no way I could have done that in January of 2020. Virtual proceedings are one of the lessons learned from the pandemic that will be used long after it dissipates. We found that for many proceedings with few participants and limited evidentiary disputes, Zoom hearings can be as effective and often far more efficient than traditional proceedings with everyone in a courtroom. For example, many lawyers prefer calendar calls and status conferences conducted online, which they can participate in from their offices, rather than having to drive from courthouse to courthouse, find parking, schlep through security, and then wait in the courtroom till their case is called. And it saves money for clients, too. Most courts have also moved to using video conferences for initial appearances and bond hearings in criminal cases. That reduces the time, cost, and security risks involved in transporting defendants between detention facilities and courthouses for these usually short and straightforward proceedings. As another example, Chief Judge Bobby Reeves of the Middle Judicial Circuit in Southeast Georgia reports that it's not unusual now for his court to deal with multiple habeas corpus petitions in a single day, sometimes as many as 5 or 6 cases. These hearings involve prisoners challenging their convictions after appeal. In the past, the judge in that 5-county circuit had to travel to the courthouse in the county where the prison is located. The inmate needed to be securely transported to and held at the courthouse. The lawyer representing the state had to travel from Atlanta or Augusta. Witnesses also had to travel, and the schedules of all of those participants had to be coordinated. Now the hearings are usually conducted by video conference with the consent of the parties. Judge Reeves presides from his home courthouse in Emmanuel County. The prisoner participates from the prison, usually in Washington County, the state's attorney from his or her office, the witnesses from their homes or offices, and with all the travel eliminated, there are many fewer schedule conflicts and lower costs for all involved. We recognize that some participants in court cases do not have good access to the internet, including many self-represented litigants in magistrate and other courts. Judges have been creative in providing electronic devices and secure spaces in courthouses, or even devices with hotspots that can be used in vehicles outside the courthouse to ensure fair access to these proceedings for all involved. Many of these virtual proceedings can and should be part of the judicial system's new normal when COVID becomes just a memory. And looking forward, I also have the hope that the technological lessons that we've been learning can help with long-standing concerns about access to justice by poor and lower-income Georgians who need legal help with issues affecting their families, health, homes, and jobs. One of the biggest challenges for access to justice in this state is that most of Georgia's lawyers are in Metro Atlanta or other larger cities, while much of the need for free pro bono or low-cost legal services is in parts of the state with few lawyers. Now that we've learned that judges, lawyers, and litigants don't always have to be in the same physical location to participate in court proceedings, perhaps we can find ways to bridge this gap. My newest colleague on the Supreme Court, Justice Verda Colvin, is chairing the Judicial Council's Access to Justice Committee, and she's an energetic proponent for ensuring that all Georgians have the ability to get the legal advice they need. But many judicial proceedings cannot be done effectively or even lawfully by video conference. These proceedings require their participants to be live and in person in a courtroom, and they often involve a significant number of participants. It's very important to keep in mind that most of the people who come to our courtrooms are not there by choice. Georgians can decide what level of COVID risk they are comfortable with before they go to a grocery store or a Braves game. But litigants and lawyers may need to come to courtrooms to get their cases resolved. Witnesses are often compelled to be there by subpoena, and jurors are there because they were summoned and would be subject to contempt if they fail to appear. Because we require these people to come to court, we also have an obligation to ensure that the conditions there are safe for them. So judges across the state have triage cases to determine which ones really need to be in person and in what priority. To limit the number of people in courthouse hallways and courtrooms at any one time, judges have split up case calendars and spread them throughout the day, with some courts using procedures for participants to wait in their cars until being notified that it's time to enter the building. Many court clerks have set up secure drop boxes outside courthouse doors to reduce contact between people filing papers and staff. All of these innovations are helpful, but the number of courtroom participants is largest for jury trials, which are also the ultimate proceeding in our judicial system. All Georgians have the constitutionally protected right to have their criminal cases and many of their civil disputes resolved by a jury of their fellow citizens. And jury trials require a lot of people: the judge, courtroom clerk, court reporter, bailiffs for security, the litigants and their lawyers, witnesses, the jurors and usually a few alternates, and at the start of the trial, dozens and sometimes hundreds of prospective jurors from which the trial jury will be selected, plus family members, victims, media representatives, and members of the public who want to watch the trial as it's their constitutional right. Now think about the Georgia trial courtrooms that you've seen on TV or been in yourself. They're usually not large to start with. Before COVID, we squeezed the jurors together on one side in what we called the jury box, with the witness stand, the judge's bench, clerk's desk, and tables for litigants and lawyers all close at hand, because all the participants need to be able to see and hear the proceedings. And during breaks and final deliberations, we sent the jurors to sit together in an even smaller room. We had all these folks sit in tight spaces for hours a day and days and sometimes weeks on end. That way of doing things is a recipe for the spread of a dangerous respiratory virus like COVID. So when COVID rates are skyrocketing, as they were in the spring of 2020 and again in the winter of 2021, and with the Delta variant last fall, and recently with the Omicron variant, there may be no way to conduct jury trials in a way that adequately protects the health of those involved. When rates are more moderate, however, our judges have figured out ways to safely conduct jury trials, even high-profile trials that last for several weeks. They've done so by requiring masks and improving ventilation and sanitation. They've reconfigured courtrooms to socially distance jurors and other participants, or when the courtrooms just weren't big enough to accommodate jury trials and jury selection, they borrowed or rented larger facilities where possible. In Douglas County, for example, Chief State Court Judge Eddie Parker explains that the judges modified their 2 courtrooms by moving benches and desks to allow socially distanced trials for misdemeanor crimes, which used 6-person juries. But there still wasn't enough room for civil trials that required 12 jurors, so the court approached the Douglas County Commission to obtain use of the Citizens Hall, where several jury trials have since been held very safely. Working with court administrators, sheriffs, and other stakeholders, courts have used the Classic Center in Athens, the James Brown Arena in Augusta, the ice rink at the Columbus Civic Center, and other alternate facilities for trials or jury selection. Now, acoustics and sound problems are a particular problem in these larger spaces, so they require creative solutions like the wireless headsets that the Augusta Superior Court obtained for prospective jurors, parties, and lawyers to be able to clearly hear the questioning in that huge facility. And there's also often a major challenge with holding criminal trials with detained defendants in these alternate spaces, because they usually don't have secure holding cells, meaning that many more sheriff's deputies are required at a time when most sheriff's departments are stretched thin. Technology can still help to some extent. Fulton County Chief Judge Christopher Brasher and his fellow Superior and State Court judges have developed a method for selecting jurors remotely in civil cases. Judge Brasher estimates that since last June, more than 75 juries have been selected for civil trials using Zoom. The Fulton County courts are seating more than half of the potential jurors summoned that way, which is a rate much higher than when jury summonses were in person only. While some lawyers have been hesitant about the process, Judge Brasher notes that many prospective jurors seem to open up and respond more to questions when they're sitting alone in their home or in another known and safe-feeling environment rather than in a courtroom surrounded by dozens of strangers. Judge Brasher also reports that the reaction of prospective jurors has been overwhelmingly positive. Other courts in Georgia are starting to use this remote jury selection process, and it's another of the innovations that should outlast the pandemic. But remote jury selection is used only for civil trials. And even with all the creativity our judges have shown, as long as social distancing and other health measures are required, the number of jury trials will be far below what it was before the pandemic. For example, Judge Kell says that the Cobb County Superior Court would often conduct 7 or 8 jury trials a week prior to the pandemic. The most they can conduct now with social distancing and other precautions is 3, less than half the pre-pandemic rate. Judge Wade Padgett also notes that while he and other Superior Court judges in the Augusta area have worked hard to resolve cases that were likely to result in jury pleas, in guilty pleas, or in civil settlements, what's left now are the hardest and most complex cases that are more likely destined for trial. And keep in mind that a civil settlement can be conducted completely on paper, and a guilty plea hearing may take 30 minutes, but a trial often lasts for several days or even weeks. So even when not halted entirely, our judicial system's capacity to conduct jury trials and other proceedings that need to be done in person is significantly lower because of COVID. That's led to significant backlogs, particularly of the serious criminal cases that are the most likely to go to trial and have long and complicated trials, including many gang-related and other trials with multiple defendants. Multiple defendants multiplies the participants in a trial. Dougherty County, for example, has at least 5 pending serious violent felony cases with 8 or more defendants. But there are also backlogs in domestic cases, personal injury cases, business cases, and all sorts of other cases in all of our trial courts: superior courts, state courts, juvenile courts, probate courts, magistrate courts, and municipal courts. Judges are acutely aware that all of these cases are important to the litigants and the community. We must always remember that court cases are about real people, our fellow Georgians. Defendants accused of crimes and detained in jails without bond, waiting for a trial to determine their guilt or innocence. Crime victims waiting for some justice. children in limbo as divorce cases and child custody disputes languish, injured plaintiffs who are waiting and struggling to survive until they can be awarded compensation, business owners who are trying to operate under the cloud of pending litigation. We're working hard and we're working together to try to restore and expand the capacity of our judicial system to resolve cases, especially those requiring trials. You provided the courts with some much needed statutory tools in your last session. You authorized judges to extend statutory speedy trial deadlines at the local level for a time, even after formal judicial emergencies end, so criminal defendants are not required to just be released without even having a trial. You allowed more criminal cases to get started with a prosecutor's accusation instead of by grand jury indictment, and more cases to be tried by judges rather than juries where the defendant consents. And you made it easier to use alternate facilities for court proceedings. And last November, Governor Kemp allocated to the judicial system $110 million in funds the state received under ARPA, the Federal American Rescue Plan Act. These funds cannot be used to supplant normal operating budgets that let courts handle the ongoing flow of new cases being filed. The ARPA funds can be used only to obtain temporary space and hire and pay temporary personnel to address case backlogs, with a priority on backlogs of serious violent felony cases like murder, armed robbery, and aggravated sex crimes. The goal is to add more capacity with proportional funding for senior and temporary judges, as well as additional prosecutors, public defenders, court clerks, court reporters, bailiffs, and the like. The Judicial Council, through a committee chaired by Presiding Justice Boggs and staffed by the Administrative Office of the Courts, has worked diligently to establish an application process and award initial grants totaling nearly $25 million to 26 judicial circuits around the state by late December. So those funds have already started to be used. The second round of grants will be awarded later this month. A total of 42 of our 50 judicial circuits have applied for help reducing their backlogs. This has been a complicated task, but Presiding Justice Boggs, his committee, the AOC, and the judicial circuits have worked very hard, and we all greatly appreciate this financial support. But note that this ARPA funding is targeted and restricted, both by federal rules and additional limitations established by OPB. Funding for most courts in Georgia has traditionally been a shared responsibility of the state and the counties, and we need more counties to step up and contribute some of the ARPA funds that they're receiving directly to address the backlogs of cases in their county's courts. This year, every single Georgia county will receive another portion of federal COVID relief funds. Many individual counties will receive more than the $110 million the judicial branch was allocated to use in all 159 counties. The federal guidelines expressly authorize counties to use their COVID relief funding to address backlogs of cases in their courts. Fulton County has dedicated $75 million of its ARPA funds to assist its judicial system to clear out backlogs. Now, Fulton is our largest county, and it has the largest backlogs, but other counties need to assist their courts as well if we're going to get back on track. We've been working with ACCG to help communicate the urgency of this issue to county leadership. Because in the end, the issue is not just the backlogs of cases that have built up over the past 2 years. New cases keep getting filed in all of our courts, sometimes at higher rates than before the pandemic, where crime rates have increased. So let's pray that we'll soon see COVID risks reduced to the point that we can get rid of social distancing and other health precautions and get our jury trial rates to back what they were before the pandemic, back to 100% of what we considered normal capacity. Well, in many counties, the judicial system operated at maximum capacity before the pandemic hit. They were barely able to handle the number of jury trials required based on new cases coming into the courts each year. This is demonstrated by the fact that a pre-pandemic caseload analysis by the Judicial Workload Assessment Committee identified the need for 8 new Superior Court judges in circuits around the state. All of these newly filed cases still need to be handled, and now add on top of them all the cases that have not been able to be resolved in the normal way over the past 2 years. I want to offer you a way to think about what our courts are facing. The Atlanta Braves canceled 102 games during the 2020 baseball season due to COVID. Those games were just canceled forever, not postponed to be resolved later like court cases have to be. What if those games eventually had to be played, and the Braves had to postpone another 102 games last season? They would be looking at an upcoming season with the usual 162 games, plus 102 games from the 2020, and another 102 games from 2021. That's a 366-game season, and I'm not sure that even our World Series champs could handle that. This is the situation some of our courts are facing right now with their overall caseloads. Let me give you a few specific examples from around the state. We have a rural judicial circuit on the coast that has 4 prisons. It has more than 200 serious violent felony cases pending, 33 coming from the prison system alone. A Northeast Georgia rural circuit has a total pending caseload 2/3 higher than before the pandemic, including 53 serious violent felony cases. The 6-county Southwestern Circuit had 377 open felony cases in 2019. Now it has more than 900. Muskogee County in West Georgia has almost 300 serious violent felony cases pending, including more than 100 detained defendants charged with murder. And these are just the indicted serious violent felony cases. They don't include cases in which the defendants have been arrested but not yet indicted, all the other sorts of criminal cases, much less all the civil cases. So this will be the main issue that the judicial system in Georgia will be dealing with, not only until the rest of our state and society return to more normal conditions, but for several years to come. I can pledge to you the continuing diligence and creativity of Georgia's judges at all levels, but we will need support and patience from you and from the public as we struggle to keep up with new cases while also resolving the cases backlogged due to COVID. I want to mention one last pandemic-related issue. Studies have shown that people with mental illnesses are more likely to be incarcerated than hospitalized. Our jails have become our de facto mental institutions, and our criminal justice system has struggled for many years with how to deal with offenders who have unaddressed behavioral health issues. The pandemic has significantly magnified these challenges. I know that improving our mental health system across the board is a priority for Speaker Ralston and for many of you. Presiding Justice Boggs and Judges Brian Amiro and Sarah Harris served on the Behavioral Health Reform and Innovation Commission, and Georgia's judges support these efforts and stand ready to assist. One effective method of dealing with nonviolent offenders who have behavioral health issues is our accountability courts, which the General Assembly and the Governor have been so supportive of in recent years. These courts, including mental health courts, veterans courts, drug courts, and DUI courts, deal with criminal defendants with much greater frequency and depth than traditional courts, as they address the behavioral health issues and other issues that often lead nonviolent individuals into our criminal justice system. Our accountability courts have had to be particularly creative during the pandemic in balancing remote and in-person check-ins, group meetings, and treatment sessions. But they have continued to be successful in reducing recidivism rates, saving the state money by allowing offenders to re-enter society and the workforce rather than being incarcerated, and most importantly, saving lost souls. But beyond accountability courts, communities across Georgia need more resources to serve our fellow citizens with mental health issues. Addressing this problem is not just good for our justice system and our economy, it's a moral imperative for our state. I'd like to end on a positive note. In December, the Supreme Court of Georgia celebrated its 175th anniversary with a 2-day history seminar. I want to thank the Georgia Legal History Foundation, which organized the event along with my colleague, Justice Carla Wong McMillan. In listening to the speakers at that event, I was struck by how much our Supreme Court has changed over the years. We've grown from 3 justices in 1846 who traveled around the state by horse and buggy to hear cases. to 9 justices with chambers in the state's first building dedicated to the judiciary, who now have the ability to hear cases by video conference when necessary. There are only 3 former female Supreme Court justices, but we now have 4 women serving as justices at the same time. Yet some things don't change. We remain one of the busiest high courts in the nation. We disposed of nearly 1,400 cases in 2021, including issuing 239 full opinions. That's more than 3 times as many opinions as the U.S. Supreme Court issued in its last term. But most importantly, our fundamental mission has never changed. Like all courts in Georgia, we remain focused on providing an independent and impartial forum in which disputes are resolved through a fair and efficient process in accordance with the law and with equal justice for all. That mission has been challenged in many ways over the centuries, and the pandemic crisis has certainly been a significant new challenge. But Georgia's judges and the staff that support us are resilient and resourceful. We're weathering this storm and will emerge better than we were before. You are very valued allies in our mission, and we appreciate everything you do for our state and for the citizens who we serve together. Thank you again for the opportunity to report to you on the state of our judiciary. May God continue to bless the United States and the great state of Georgia.
Important.
Thank you, Justice Nahmias, for your remarks and just a great reflective look back as to how hard you and your colleagues have worked all throughout the judicial system through this unprecedented time, and grateful for your commitment to carrying out justice in our great state of Georgia. Madam Doorkeeper, please escort the Chief Justice, the justices of the Supreme Court, and the judges of the Court of Appeals from the chamber at this time.
Thank you, Governor.
At this time,